I was standing on my front porch watching the sun rise over Lake Morrison when I noticed something strange about the water level. It had dropped at least 2 feet overnight, exposing muddy banks and dock posts that hadn't seen daylight in years. My property in Riverside Estates, just outside of Boulder, Colorado, had always been my pride and joy, especially because I owned the small dam that controlled water flow from the natural spring feeding into the lake. What I didn't know that morning was how much my life was about to become a living nightmare, all because of one woman named Brenda Hollingsworth and her crusade as president of our homeowners association. I had purchased my property back in 2019, a beautiful 5-acre spread with the dam already on it. The previous owner, an elderly man named Gerald, had explained that the dam was built in the 1960s by his father on private land, long before the HOA even existed. The deed clearly stated that I owned not just the house and land, but also the dam structure and the rights to manage water flow. I had all the paperwork locked away in my safe, though at the time I bought the place, I never imagined I would need it for anything more than insurance purposes. My name is Quincy Whitmore, and I have lived a pretty quiet life. I work as a civil engineer, which ironically made me more than qualified to understand property rights and water management. My wife passed away 3 years ago, and since then, the lake house had become my sanctuary. I spent my weekends fishing, maintaining the property, and occasionally adjusting the dam gates to ensure proper water levels for the whole community. It was a responsibility I took seriously, and the previous owner had taught me everything about how the system worked before he moved to Arizona. The trouble started on a Tuesday morning in late April when Brenda showed up at my door unannounced. She was a woman in her mid-50s with shoulder-length blonde hair that looked like it had been shellacked into place, wearing a purple blazer that was at least one size too small. Her lips were pursed so tight they looked like a drawstring bag someone had pulled closed. "Mr. Whitmore," she said without any greeting or pleasantries, "I am here on official HOA business regarding unauthorized alterations to community water resources." I blinked at her, still holding my morning coffee. "I'm sorry, what?" "The lake level," she said, gesturing dramatically toward the water. "You have been tampering with it without board approval. This is a direct violation of the community standards outlined in Section 12, subsection 4 of the HOA bylaws." I took a slow sip of my coffee, trying to process what she was saying. "Brenda, I own the dam. It's on my property. I haven't tampered with anything except normal maintenance." Her face turned an interesting shade of red. "The dam may be on your property, but the lake is a community resource. Every homeowner in Riverside Estates has a right to consistent water levels. You cannot just make changes whenever you feel like it." I lowered it slightly because we have heavy snowmelt coming and I wanted to prevent flooding, I explained, keeping my voice calm. "It's basic water management. I'll raise it back up in a few days." "You will do no such thing without written approval from the HOA board," Brenda snapped. "We meet next Thursday. Until then, you are to cease all dam operations immediately." I felt my jaw tighten. "That's not how this works. I have a legal right to manage my property." "We will see about that," she said, then turned on her heel and marched back to her golf cart. I should have known right then that this was going to escalate, but I honestly thought common sense would prevail. I was wrong. 2 days later, I received a certified letter from the HOA's legal team demanding that I cease all dam operations pending a full review by the board. The letter was full of legal jargon and thinly veiled threats about fines and possible legal action. I read it 3 times, then called my own attorney, a sharp woman named Patricia Hayes, who I had worked with on my wife's estate. "Can they do this?" I asked her over the phone. Patricia was quiet for a moment and I could hear papers rustling. "Send me all your deed documents and the HOA bylaws. Let me review everything and I'll get back to you." She called me back the next afternoon. "Quincy, you're in the clear legally. The dam predates the HOA by decades, and your deed explicitly grants you control over it. The HOA has no authority over privately owned structures on private land, even if they affect community amenities. But I will warn you, they can make your life difficult." "How difficult?" I asked. "Fines, liens on your property, constant harassment. Some HOAs can be ruthless when they think their authority is being challenged." She was right. The next week, I received a fine for $500 for unauthorized modification of community resources. The week after that, another fine for $1,000. Then they started finding other violations. My lawn was apparently half an inch too long. My mailbox needed repainting. My driveway had a small oil stain that violated aesthetic standards. Every single day brought a new citation, a new fine, a new headache. I attended the HOA meeting in May, thinking I could reason with them face to face. The meeting was held in the community center, a bland beige building with fluorescent lights that hummed like angry wasps. About 30 homeowners were there, sitting in folding chairs. Brenda sat at the front table with 4 other board members, all looking at me like I was some kind of criminal. "Mr. Whitmore," Brenda began once the meeting started, her voice dripping with false sweetness. "Would you like to explain to the community why you believe you are above the rules that the rest of us follow?" I stood up, my folder of documents in hand. "I'm not above any rules, but the dam is my private property, and I have legal documentation proving that. The HOA has no jurisdiction over it." One of the other board members, a man named Richard who owned a car dealership in Boulder, leaned forward. "Mr. Whitmore, we understand your position, but you need to understand ours. This community has standards. We can't have individual homeowners making unilateral decisions that affect everyone." "I'm not making unilateral decisions," I said, fighting to keep my frustration in check. "I'm managing water levels to prevent flooding and ensure the dam operates safely. This is what I've been doing for 5 years without any problems." A woman in the back raised her hand. "My dock was completely exposed last week. I couldn't even get my boat in the water." "That was temporary," I explained. "The water is back to normal levels now. I had to lower it because of the spring runoff. If I hadn't, half the properties on the South Shore would have flooded." Brenda cut me off. "The point is, Mr. Whitmore, that you made that decision without consulting anyone. This is a community, and in a community, we make decisions together." "Not about my private property, we don't," I said firmly. The meeting devolved from there. Other homeowners started chiming in, some supporting me, others siding with Brenda. It ended with the board voting to pursue legal action if I didn't sign over operational control of the dam to the HOA. I refused, and I walked out knowing that this fight was far from over. June brought the lawsuit. The HOA filed a complaint in Boulder County District Court, claiming that my control of the dam constituted a nuisance, and requesting that the court order me to either surrender control to the HOA or pay damages for lost enjoyment of property to all affected homeowners. The damages they were seeking totaled over $200,000. I sat in Patricia's office reading the complaint, feeling my blood pressure rise with every page. "This is insane," I muttered. "It's aggressive," Patricia agreed, "but not entirely unprecedented. HOAs have gotten bolder over the years. The good news is that we have a very strong case. Your property rights are clearly established. The bad news is that this is going to be expensive and time-consuming." "How expensive?" I asked. Could be 30 to 50,000 in legal fees before it's over. Maybe more if they drag it out. I felt sick. I was comfortable but not wealthy. That kind of money would seriously impact my retirement savings. But I couldn't let them bully me into surrendering my property rights. "Let's fight it," I said. The summer was miserable. The legal battle consumed my life. I spent hours gathering documents, preparing for depositions, and dealing with constant harassment from the HOA. They sent inspectors to my property weekly, looking for any violation they could find. They fined me for having a garden gnome that was non-compliant with aesthetic standards. They complained about the color of my window shutters. They claimed my air conditioning unit was too loud. Meanwhile, Brenda had started a whisper campaign in the neighborhood. I would be at the grocery store and see other homeowners literally turn away from me in the aisles. People I had been friendly with for years suddenly wouldn't return my waves. Someone spray-painted "HOA bully" on my mailbox one night, which was rich considering I was the one being bullied. The only bright spot was my neighbor, an elderly woman named Dorothy who lived 2 houses down. She had been in the community since the beginning and remembered when the dam was built. She stopped by one afternoon in July with a casserole and moral support. "Don't let them break you, Quincy," she said, sitting on my porch. "Brenda is on a power trip. She's been that way since she got elected. Some people get a tiny bit of authority and it goes straight to their heads." "I just want to be left alone," I said tiredly. "I'm not trying to cause problems. I'm just trying to manage my property responsibly." Dorothy patted my hand. "I know, dear, and I'll testify to that if it comes to it. I remember when your dam was built. There was no HOA back then. This was just a collection of properties around a lake. The HOA came later and started making all these rules. They can't just retroactively claim control over something they never had authority over in the first place." Her words gave me strength to keep fighting. The depositions started in August. I had to sit in a conference room while the HOA's attorney, a smarmy guy named Todd Brighton, tried to twist everything I said. He asked me questions like, "Would you agree that you have a responsibility to consider your neighbor's interests? And isn't it true that you lowered the water level without giving anyone notice?" I answered honestly, but Patricia had prepared me well. I stuck to the facts. I owned the dam. I had the legal right to manage it. I had been doing so responsibly for 5 years. The temporary water level changes were necessary for proper water management and safety. Brenda's deposition was enlightening. Patricia got her to admit that she had never actually reviewed the deed documents before filing the lawsuit. She also admitted that she had no expertise in water management or dam operations. When Patricia asked her why she thought the HOA had authority over the dam, Brenda's answer was simply, "Because it affects the community." "But doesn't Mr. Whitmore's house also affect the community aesthetically?" Patricia asked. "Does that mean the HOA can claim control over his house?" Brenda had stammered and said that was different, though she couldn't articulate how. Fall came, and with it the discovery phase. The HOA had to turn over all their documents, and Patricia found some interesting things. First, there was an email chain where Brenda had discussed the lawsuit with the board before ever talking to me. She had written, "We need to establish control over the dam to show that the HOA has authority over all community resources, regardless of ownership. This will set a precedent for future enforcement actions." It wasn't about water levels at all. It was about power and control. Second, Patricia discovered that the HOA had been planning to develop the lakefront area and wanted control of the dam so they could keep water levels artificially high for aesthetic purposes, even if it meant increased flood risk. They had already solicited bids from contractors, for building a new clubhouse on the South Shore, and one of the board members owned the construction company that had submitted the lowest bid. "This is getting interesting," Patricia said, when she showed me the documents. "They may have violated their fiduciary duty to the homeowners, and that conflict of interest with the construction bid could be serious." We filed a countersuit in October, alleging that the HOA had breached its duty to the homeowners and had initiated the lawsuit in bad faith for personal financial gain. We also asked the court to award attorneys' fees and damages for harassment. Brenda lost her mind when she was served with our countersuit. She showed up at my house screaming that I was trying to destroy the community and that I would pay for my actions. I recorded the whole thing on my phone, which later proved useful. November brought more drama. The HOA called an emergency meeting and tried to pass a special assessment to cover their mounting legal fees. They wanted each homeowner to pay an additional $2,000. The meeting turned into chaos, with homeowners yelling at the board, demanding to know why they had started this lawsuit in the first place. Several people pointed out that I had been managing the dam without problems for years, and that this whole thing seemed like a waste of money. Dorothy stood up and gave an impassioned speech about property rights and HOA overreach. "I have lived in this community for 43 years, she said, her voice shaking with emotion. "I watched that dam get built. I watched this neighborhood grow from a few scattered houses to what it is now. And never, not once, did anyone think the HOA should control that dam. Quincy Whitmore has done nothing wrong. He has been a good neighbor and a responsible property owner. This lawsuit is a disgrace, and I for one will not pay a dime to support it." About half the room applauded. The board looked stunned. They tried to call for a vote on the special assessment, but not enough homeowners voted in favor. The motion failed. That night, Brenda sent out an email to all homeowners claiming that certain individuals were trying to undermine the community, and that the board would not rest until the dam was under proper community control. The email was so over the top that even people who had initially supported the HOA started questioning Brenda's judgment. December was relatively quiet as both sides prepared for trial. The court date was set for February. Patricia was confident but cautious. "Judges don't like HOA overreach," she told me, "but they also respect property rights. As long as we can show that you have clear legal ownership and have been managing the dam responsibly, we should prevail." I spent the holidays alone, as I had every year since my wife died, but this year felt particularly isolating. The legal battle had taken over my life. I barely recognized myself in the mirror. I had lost weight from stress. I wasn't sleeping well. I spent my days either working or preparing for trial, and my nights worrying about what would happen if I lost. January arrived with a massive snowstorm that dumped 3 feet of snow on Boulder County in 1 week. The spring feeding the lake was buried under snow, and water levels dropped naturally. Several homeowners called me asking when I was going to raise the levels, apparently forgetting that they were suing me for controlling the dam in the first place. I politely explained that I was still managing the dam, and that water levels would normalize when the snow melted. Brenda sent me a nastogram threatening more fines if I didn't immediately rectify the water situation. I forwarded the email to Patricia, who sent a response informing the HOA that any further harassment would be added to our counterclaim for damages. The week before trial, something unexpected happened. One of the board members, a quiet man named Stephen, who had mostly stayed out of the fight, resigned from the board and sent a letter to all homeowners explaining why. He wrote that he had initially supported the lawsuit because Brenda had presented it as a simple matter of community standards. But as the case progressed, He had become uncomfortable with the board's tactics and motivations. He revealed that Brenda had been pressuring board members to support the lawsuit and had been using HOA funds inappropriately, including paying for personal expenses and charging expensive dinners to the HOA account. The letter was a bombshell. Homeowners started demanding Brenda's resignation. There was talk of calling a special election to remove the entire board. But Brenda refused to step down, insisting that Stephen was lying and that this was all part of my campaign to destroy the HOA. The trial finally began on February 10th. I had never been so nervous in my life. The courtroom was smaller than I expected, with wooden benches and fluorescent lights. Judge Margaret Reynolds presided, a stern-looking woman in her 60s with gray hair and sharp eyes. She had a reputation for being fair but no nonsense. The HOA's attorney, Todd Brighton, presented their case first. He argued that the dam, while technically on my property, was so integral to the community that it should be considered a shared resource. He claimed that I had been arbitrary and capricious in managing water levels, and that homeowners had suffered damages as a result. He brought in witnesses, including Brenda and several homeowners who complained about water levels affecting their boat docks and property values. During cross-examination, Patricia demolished most of their arguments. She got one witness to admit that water levels had always fluctuated seasonally, even before I owned the property. She got another to admit that they had never actually suffered any financial damages. And she got Brenda to admit again that she had never consulted any water management experts before filing the lawsuit. Then it was our turn. Patricia presented our deed documents, clearly showing that I owned the dam and had full control over it. She brought in the historical records, showing that the dam predated the HOA by decades. She presented expert testimony from a hydrological engineer, who explained that my water management practices were not only reasonable but necessary for preventing floods and maintaining the dam's structural integrity. Dorothy testified about the history of the neighborhood and the dam. She was a fantastic witness, speaking clearly and confidently about how the HOA had never had authority over the dam and how I had been a responsible manager of it. I also testified. Patricia walked me through my background as a civil engineer, my purchase of the property, and my management of the dam. I explained every decision I had made regarding water levels, showing that they were all based on sound engineering principles and safety concerns. I talked about the harassment I had endured and the financial and emotional toll this lawsuit had taken on me. When Todd cross-examined me, he tried to make me look selfish and uncaring about my neighbors. "Mr. Whitmore, don't you think you have a moral obligation to consider how your actions affect others?" "Of course I do," I said. "That's exactly why I manage the dam the way I do. If I kept water levels artificially high like the HOA wants, we would risk flooding during heavy snowmelt. That would damage multiple properties and could potentially cause the dam to fail. My decisions are based on protecting the entire community, not just my own interests." "But you make those decisions unilaterally," Todd pressed. "I make them based on engineering principles and safety standards," I corrected. "Just like I make decisions about my house, my septic system, or any other part of my property unilaterally. That's what property ownership means." The trial lasted 3 days. Closing arguments were on February 13th. Patricia gave a powerful summation, arguing that this case was about fundamental property rights and HOA overreach. She pointed out that if the court ruled in favor of the HOA, it would set a dangerous precedent allowing HOAs to claim control over any private property that might affect the community. Todd argued that communities have a right to protect their collective interests, and that individual property rights should sometimes yield to community needs. Judge Reynolds took the matter under advisement and said she would issue a ruling within 2 weeks. Those 2 weeks were agony. I couldn't eat, couldn't sleep, couldn't focus on anything. I had already spent over $40,000 on legal fees. If I lost, I would owe the HOA damages and might have to surrender control of my dam. Everything I had worked for, everything my property meant to me, was hanging in the balance. The ruling came down on February 27th. Patricia called me at 9 a.m. "Quincy, we won. We won everything." I actually started crying. I'm not ashamed to admit it. The relief was overwhelming. Judge Reynolds' written ruling was 32 pages long and left no doubt about where she stood. She wrote that the HOA had failed to establish any legal basis for claiming authority over privately owned property that predated the HOA's existence. She noted that my management of the dam had been reasonable, responsible, and based on sound engineering principles. She explicitly rejected the HOA's argument that community interest could override clear property rights, but she went further. She ruled that the HOA had acted in bad faith by filing the lawsuit without proper investigation of the legal issues. She found that the evidence of conflict of interest regarding the construction bid was deeply troubling and suggested that the current board might have violated their fiduciary duties to the homeowners. She awarded me full attorney's fees, totaling $43,000, to be paid by the HOA. She also awarded me $25,000 in damages for harassment and emotional distress. And then came the key paragraph that made my day. The court confirms that Quincy Whitmore has full legal control over the dam structure on his property and all operational decisions related thereto. The Riverside Estates Homeowners Association has no authority over said dam, and any future attempts to interfere with Mr. Whitmore's property rights may result in sanctions and additional damages. I read that paragraph 5 times. The judge had confirmed I control the dam legally. It was over. But it wasn't quite over yet. The judge's ruling had exposed the board's misconduct, and homeowners were furious. A petition circulated calling for Brenda's immediate removal. The HOA's insurance company, which had been covering their legal fees, sent a letter declining to cover the damages award because the board had acted outside the scope of their authority. An emergency HOA meeting was called for March 5th. I decided to attend. I walked into that community center with my head held high for the first time in months. The room was packed. Every seat was filled, and people were standing along the walls. Brenda sat at the front table looking pale and defeated. The other board members looked miserable. Dorothy stood up and moved to remove Brenda from the board for cause. The motion needed a 2/3 vote of attending homeowners. The vote wasn't even close. 87% voted to remove her. The other board members resigned on the spot rather than face similar votes. Brenda stood up, her face red with anger and humiliation. "You are all making a terrible mistake," she said. "Without proper oversight, who knows what Whitmore will do with that dam? You'll all regret this." "The only thing we regret," Dorothy said firmly, "is that we didn't stop you sooner. You abused your position, wasted community money, and harassed a good man for no reason other than your own ego. Please leave." Brenda gathered her papers and walked out. I never saw her again. I heard later that she and her husband put their house up for sale and moved to Arizona. Good riddance. The new board, elected at that same meeting, was composed of level-headed people who actually cared about the community rather than power trips. Their first act was to formally apologize to me and to pass a resolution acknowledging my property rights over the dam. Their second act was to hire a forensic accountant to review the previous board's spending. That review eventually revealed that Brenda had spent over $15,000 of HOA money on personal expenses, including spa trips, expensive dinners, and new furniture for her house that she had claimed was for the community center. The HOA filed a civil suit against Brenda to recover the misappropriated funds. She settled out of court for $12,000. Some homeowners wanted to press criminal charges, but the district attorney declined to prosecute, saying it would be difficult to prove criminal intent rather than just poor judgment and record keeping. Life slowly returned to normal. The HOA paid me the $68,000 I was owed from the judgment. I used it to replenish my savings and make some long overdue improvements to my property. I also invested in better gates and controls for the dam, making it easier to manage water levels precisely. Spring brought heavy snowmelt, just as I had predicted the year before. Because I had been managing water levels properly all along, there was no flooding. Some of my neighbors actually thanked me for preventing what could have been serious water damage to their properties. It was vindicating after everything I had been through. Dorothy and I became good friends. She had stood by me when almost everyone else had turned away, and I would never forget that. We started having dinner together once a week, and she helped me learn to cook better meals. She said I needed someone to look after me, and while I had initially bristled at the idea, I had to admit it was nice to have someone who cared. In May, the new HOA board asked if I would be willing to serve as an advisor on water management issues. They wanted to make sure the community understood how the dam worked and why certain decisions were made. I agreed, and I started sending out quarterly reports explaining water levels, projected seasonal changes, and any maintenance work I was planning. The transparency helped a lot. People understood that I wasn't making arbitrary decisions, but was actually carefully managing a complex system. I also started offering tours of the dam for interested homeowners. I showed them how the gates worked, explained the engineering principles involved, and answered questions. It demystified the whole thing and helped people understand that dam management was serious business, not something to be taken lightly or controlled by committee. Life wasn't perfect, but it was peaceful again. I could fish from my dock without worrying about HOA inspectors lurking around looking for violations. I could maintain my property without getting nastagrams about grass length or mailbox paint. I could manage my dam responsibly without lawyers breathing down my neck. One evening in late June, I was sitting on my porch watching the sunset reflect off the lake when Dorothy walked over with a pie. "Thought you might like some company," she said. "Always," I replied, getting her a chair. We sat in comfortable silence for a while, then Dorothy said, "You know, you did the community a favor by standing up to Brenda. She would have kept getting worse if someone hadn't stopped her." "I didn't do it for the community," I said honestly. "I did it because she was wrong and I wasn't going to let her steal my property rights." "Sometimes doing the right thing for yourself is also doing the right thing for everyone else," Dorothy observed. She was right. The lawsuit had been horrible to endure, but it had exposed serious problems with the HOA leadership and led to real reforms. The new board was transparent, responsible, and actually served the homeowners rather than their own egos. The experience had taught the community important lessons about property rights, HOA limitations, and the dangers of giving too much power to people who enjoyed wielding it. As summer progressed, I found myself healing from the trauma of the previous year. I was sleeping better, eating better, and actually enjoying my property again. The lake had become a source of peace rather than stress. I spent my weekends working on a small boat I was building in my garage, fishing, and hosting occasional dinners for Dorothy and a few other neighbors I had reconnected with. In August, I got an unexpected call from a reporter at the Boulder Daily Camera. She had heard about the lawsuit and wanted to do a story about HOA overreach. I was hesitant at first, but Patricia encouraged me to do it. "Your story could help other people dealing with similar situations," she said. The article ran in September and generated a lot of interest. I got emails and calls from people across Colorado and even other states who were fighting their own battles with overreaching HOAs. I shared my experience and the legal strategies that had worked for me. Some people sent me copies of their own property documents asking for advice. I wasn't a lawyer, so I couldn't give legal advice, but I could point them to resources and encourage them to document everything and stand firm on clear property rights. The article also caught the attention of a state legislator who was working on HOA reform legislation. She called me and asked if I would be willing to testify before a committee about my experience. I agreed, and in November I found myself in the state capitol in Denver, telling my story to a room full of legislators. The bill that eventually passed in the following legislative session included provisions requiring HOAs to conduct proper legal review before filing lawsuits, establishing clearer limits on HOA authority over pre-existing private property, and creating better mechanisms for homeowners to challenge improper fines and actions. The governor signed it in March, and it became known informally as the Property Rights Protection Act. I was invited to the signing ceremony, and the governor shook my hand and thanked me for bringing attention to an important issue. I never expected to become any kind of advocate or public figure. I just wanted to be left alone to manage my property in peace. But sometimes life takes you in unexpected directions, and you find meaning in struggles you never wanted to face. 2 years after the lawsuit ended, I was still living in my house by the lake, still managing my dam, and still enjoying the peaceful life I had fought so hard to protect. The HOA was functioning well under competent leadership. Property values in the neighborhood had actually increased, partly because potential buyers felt more confident knowing that property rights were respected, and the HOA wasn't out of control. I had even started dating someone, a woman named Linda, I met at a community barbecue. She was a teacher in Boulder, recently divorced, and she appreciated a man who stood up for what was right. We took things slowly, but it felt good to have companionship again after so many years alone. Dorothy approved, which somehow mattered to me. "It's about time," she said when I told her. "You're too young to spend the rest of your life alone with just that dam for company." "The dam is very good company," I joked. "It doesn't talk back." "Neither does a rock," Dorothy retorted, "but that doesn't make it a good companion." Looking back on everything that happened, I realized that the lawsuit, as awful as it was, had ultimately made me stronger. It had forced me to fight for what was mine, to stand up to bullies, and to trust in the legal system even when things looked bleak. It had shown me who my real friends were, and had connected me with people and causes I never would have encountered otherwise. The dam still stands on my property, its concrete structure solid and dependable. I maintain it carefully, adjust the gates as needed for seasonal changes, and take pride in knowing that I am protecting not just my property, but the entire community from flooding and water damage. The judge confirmed I control the dam legally, and that confirmation gave me not just legal victory but vindication and peace of mind. Every morning when I have my coffee on the porch and look out at the lake, I remember how close I came to losing everything. I remember the stress, the fear, the anger, and the exhaustion of fighting a lawsuit I never wanted. But I also remember the satisfaction of winning, of proving that property rights matter, and of standing up to people who thought they could use bureaucratic power to take what wasn't theirs. The lake level sits exactly where it should be for late summer, about 3 feet below the spring high water mark. The exposed shoreline will be covered again when autumn rains come, and then I'll adjust the gates to prepare for winter. It's a rhythm I understand intimately now, a cycle of management and stewardship that I take seriously. Brenda is gone, her brief reign of HOA terror ended by her own overreach and arrogance. The community is stronger for her absence. The new board understands that their role is to serve homeowners, not rule over them. Property rights are respected, common sense prevails, and I am still here, still standing, still in control of my dam and my destiny. The legal battle tried to break me, but instead it proved what I was made of. Judge Reynolds's ruling sits framed in my office, a reminder that justice, though sometimes slow and expensive, does eventually prevail. On quiet evenings, Linda and I sit by the water and watch the sun set over the mountains. Dorothy sometimes joins us, bringing pie and wisdom. We talk about ordinary things, about books and movies and plans for the weekend. We don't talk about HOAs or lawsuits or property rights. We don't need to anymore. The story of my fight with the Riverside Estates, HOA, became something of a local legend, a cautionary tale about the dangers of HOA overreach, and a hopeful story about standing up for what's right. People still occasionally recognize me from the newspaper article or the legislative testimony. Some thank me for making a difference. Others just nod in solidarity, fellow warriors in their own battles with petty bureaucrats and power-hungry board members. I never wanted to be a symbol or a crusader. I just wanted to live peacefully on my property and manage my dam responsibly. But sometimes ordinary people are thrust into extraordinary circumstances, and the only choice is to fight or surrender. I chose to fight, and I won. The dam remains mine, legally and absolutely. The judge confirmed it, the community accepts it, and the HOA respects it. That's all I ever wanted. That and the peace to enjoy my morning coffee, watch the water, and live my life without harassment from people who thought they knew better than decades of legal precedent and common sense. As autumn approaches and I prepare for another cycle of water management, I feel grateful for everything I have. A beautiful property, good friends, a promising relationship, and the legal right to control my own dam. It seems simple, but after everything I went through to protect those things, I know how precious and fragile they can be. The lake reflects the changing colors of the cottonwood trees along its banks. The water is clear and calm. The dam operates smoothly, its mechanisms well maintained and reliable. Everything is as it should be, as I fought to keep it, as the law says it must remain. I control the dam, legally and completely. Judge Reynolds confirmed it, and no HOA will ever take that away from me. That's not just a legal victory. It's peace of mind, validation, and justice. And it's mine forever.